Nigeria, good people, great nation. Few weeks ago, the Independent National Electoral Commission, I.N.E.C, deregistered no fewer than 28 political parties out of the over 60 existing ones in our democratic landscape. Many political pundits believe that the action of I.N.E.C was done in good faith, at least to put sanity into the political activities in the country. However, some politicians whose parties were affected in the exercise felt bad as they cried for justice and even threatened to seek judicial intervention for their rights. Let us imagine a political scene with almost 63 political parties contesting an election. Though the Democrats said it is good for democracy, but how will one place the burden of those inactive parties on I.N.E.C? For instance, during an election, the electorate will have to battle with a bedspread ballot paper with 63 names and party logos. It is going to be confusion galore in the polling booths. I don't think we need a soothsayer to inform us that some of these political parties merely exist on the pages of newspapers and just as symbols of structure to occupy a space in the record book of I.N.E.C. Perhaps they exist for the purpose of collecting allocations from the I.N.E.C to further service the political machinery of the party chairmen and their families. 50 years after independence, the country should be talking of quality and not quantity of political parties. How these parties are prepared to add value to the living standard of an average Nigerian, I don't know. Can any of these deregistered parties be of good faith to Nigeria? Are they adding value to our political system? Do you ever think Nigeria should parade as many as 63 political parties in the first instance? How many of the 63 registered parties can justify to be called a political party? And considering the fact that none of the 28 registered political parties could boast of one single ward councillor anywhere in the country, was I.N.E.C not right to have listed them? Good evening once again. This is Crossfire, and I am Banjo Abitogun. With me on the panel tonight, I have from my extreme right, Barrister Babs Akinwumi. Barrister Akinwumi is a legal practitioner. He's also a human rights activist. You're welcome, sir.
Thank you.
To his left, I have another barrister, Barrister Taiwo, Kayode.
Good evening, sir.
From the title, you know he's a legal practitioner too. You're welcome to the program, sir.
Thank you, sir.
And to my immediate right here, I have Honorable Adeyinka Banso. Honorable Banso is a legal practitioner by profession. He's also a lawmaker, and in fact, he's a member of the Ondo State House of Assembly. You're welcome, sir.
Good evening.
Still expecting on the program tonight also is Chief Olumuyiwa, who will be here with us any moment from now. Once again, good evening. This is Crossfire. Straight to business. Barrister Akinwumi. In registering the former 63 political parties, what do you think were the parameters used by I.N.E.C?
Basically, before those parties were registered, late Chief Gani Fahimi was in court to say that there was an infringement on right of association. Because of this, the Supreme Court said, no, you can't limit the freedom to right of association. People are free to form association. But we will come to that. Because I feel that Supreme Court even made mistake to say that political parties are associations. But when we get to that, we will go into it. For you to have a political party registered, you must have a national headquarters in Abuja is a condition. You forward the names of the trustees to I.N.E.C. These are the conditions you need to meet. Section 22.222 of the Constitution empowers I.N.E.C to register political party. Section 78 of the Electoral Act 2010 empowers I.N.E.C to register political party. So these are requirements you need to meet. You send the names of your trustees. You have a national office in Abuja and offices in all the 30 states of the country. These are the conditions.
What about the local governments and the wards?
Well, they said national headquarters, then in all the states.
Yeah. So if somebody is rich enough to rent a property in Abuja and other properties in the 36 state capitals,
yes,
he can form a political party.
Very well.
Barrister Kayode, Do you agree with that?
Well, I agree with my learned colleague. If you look at the provisions of Section 2.2 of the 1999 Constitution as amended, is to the effect that before a political party can be registered, it must have its national office at Abuja, and there is a provision that, well, they must have constitution, and their ESCOs must equally be in place, and more importantly, that the Section 222 expressly equally stated that the ESCOs must reflect the geographical character of Nigeria. The ESCOs must not be from Southwest alone or Southeast. It must be from every state of the Federation. If you are able to meet those requirements, then a political party has been formed.
Okay, before going to the real question I was going to ask Honorable Banso, do you think most of these political parties met the stipulations my learned friend has just said? It's my learned friend because I'm training to be a lawyer.
You're a near colleague.
Thank you very much. Honestly, in addition to what the previous speakers have said, the part of the conditions precedent for registration of political parties is that, as he has rightly said, that the composition of the ESCO, that is National Executive Committee, should reflect federal character, and it should be taken from not less than 2/3 of the states of the make up the country.
Yeah.
So that's just in
Yeah,
addition.
but did most of them meet the conditions?
Well, let me tell you, they don't. Most of them don't meet the condition. I want to say here that the registration of most of the political parties is void ab initio.
Okay.
Void in the sense that Section 78, sub 5 of 2010 Electoral Act provides that you must you must first of all you provide for the fact that when you are registering a political party, the political party must feed I.N.E.C with all relevant documents, and they must not lie. But that subsection provides that when it is found out that they have falsified a particular document, they have presented wrong information, fed I.N.E.C with wrong information, I.N.E.C, that the certificate of registration, which is the prima facie evidence that they have been registered, can be withdrawn, should be it is deemed cancelled, not even should be withdrawn, is deemed cancelled. As a result of that, you discover that when these political parties were registered, some of them presented false information to I.N.E.C. So many, more than 80% of them did that. So you discover that at the point when N.R.C registered them, most of them were not qualified for registration. So I don't know why these whoos and cries about the registration of political parties. Some of them, ab initio, did not meet the requirements.
Okay.
Well, I don't.
You got to say something?
Yes, I don't agree with the Honourable. In the sense that the provisions of the law is very, very clear in respect of registration and deregistration. When you look at the provision of the law, that is Section 2.2 of 1999 Constitution, if any political association is able to meet those requirements, that is 6 requirements, then it is sufficient for I.N.E.C to register that association as a political party. And even in reference, Section 222 of 1999 Constitution, then in its reference to Electoral Act 2010, that maybe some of these political associations did not meet that requirement. If you look at the supremacy, if you look at the Act of National Assembly, which is, of course, which the Electoral Act 2010 is, and the Constitution is very, very supreme. Any act of the National Assembly
Don't forget that
or
the
that of state
Sorry.
that is
Sorry.
inconsistent with the provision of the Constitution is void ab initio. So what I'm trying to put across is the fact that if any association is able to meet the requirement of Section 222 is sufficient. And the case referred to by my learned colleague, Balabe Musa, Ganifa Emi, and Co. versus I.N.E.C. When you see the postulation and the opinion of the Supreme Court in respect of that judgment, is to the effect that if they are able to meet the requirement of Section 222 is sufficient to register a political party. So the idea of falsification or the idea of putting in one or two things.
Sorry, maybe I have to cut in at this point. I do not subscribe to what my learned friend, the Honorable, has just said too, because in law, there's presumption of regularities when it comes from a government domain. The mere fact that they are registered is a prima facie evidence that they met the requirement before they were registered. So there's that presumption until there's a proof to the contrary that those things were falsified, which standard will now be proved beyond reasonable doubt because it will be criminal at this point. So I will not subscribe to him saying that they've falsified document or something.
Or that they have not been registered.
So it's presumed that they met up with the requirement.
If they did not met up with the requirement, even that Supreme Court judgment is to the effect that if they have met up with all those requirements of Section 222, INEC doesn't have any other power to say no, I will not register you.
So there's that presumption. We'll come back to that later. Honorable Banso, how many of these 33 parties can you say really was a political party in the real sense of it?
Well,
in terms of followership, in terms of ESCO, in terms of all these regulations and conditions.
Looking at the requirements for registration of political parties, you will discover that less than 11 out of the 63 political parties we had before the registration of these 28 were qualified to be political parties. So, most of these political parties, you know, sir, they just bear political parties by their names, and of course, you see their headquarters in the boots of their proprietors or chairman. You see their documents or the head office or what have you on the table on the dining table of most of the so-called promoters of this political party. So most of them ab initio were not fit. I maintain, you understand, that most of them were not qualified, and of course the registration fine they have said is also voidable. It's also voidable because I.N.E.C reserves the right to register political parties and also reserve the right to deregister political parties if found wanting.
Okay then. Thanks. Before we continue, I'd just like to recognize the presence of Chief Olumuyiwa, who has just come on the program. Chief Olumuyiwa, I mentioned earlier before you came in that you will be coming. Chief Olumuyiwa, for those who do not know him, is a political affairs analyst. He's a regular on this program. You're welcome, sir.
Thank you very much.
Yeah, we are discussing the registration of 20 political parties. So later we'll come to your take on that. Okay, you can continue, Honorable Banso.
Yeah. Like I did say, that less than 11, up just about 10, and when you look at that percentage, it's less than 20% of the total political parties we have in Nigeria are really actually qualified to be called political parties. Because when you look at the requirements of I.N.E.C, most of them have not even met the requirements. These political parties are supposed to make returns regularly to I.N.E.C. How many of them are making returns to I.N.E.C?
Okay.
And most of them are supposed to have head office in Abuja. How many of them have head office in Abuja? Most of them are supposed to win seats, either at the National Assembly or at the State Assembly. But how many of them even have won councillorship seat, let alone House of Assembly seat?
Okay, thank you. Let's go to Chief Olumuyiwa now. Though you have just come on, we'd just like to know what's your opinion about the 63 political parties in Nigeria. Do you think we need them?
I think they are unwieldy in the first place. Because if you look at it, in 1999, INEC, in its wisdom, registered just 2 political parties, the PDP and the APP, now ANPP. It was the machination of the AD that brought in a third party in the first instance at all. I regret to say that I was instrumental to that machination, because we had a 3-man committee, a 3-man party registration committee. I was part of the 3. I remember that time was so short, we didn't have offices where they are required. I had to download my data from my USCP days. I can't remember the full name now of USCP, under Abuja. Even I have to go back to my N.R.C days as the political advisor to the National Secretary of the N.R.C. It was those documents that I downloaded, as it were, in terms of party offices, in terms of names and addresses of officials, even though when we knew that it was not, we were not able to meet the requirements.
Okay.
We had to untwist INEC then and place on tribal politics. This is because the leadership was mainly Yoruba. That was why they don't register AD. So 2 parties will have been ideal. And I make bold to say that it was late Bola Ige that insisted. You know, don't forget he drew the party constitution of PDP, APP, and even AD.
The AD.
He felt he won't be able to participate on a level playing ground with those juggernauts. That's why he insisted we should form a third party in AD. So the 3 parties are unwieldy. They are administrative nightmare. So you can imagine, even if half of them were able to participate in a presidential election, how do you come about the ballot papers, the logos and the space and all that? I think it's about the most unwieldy political process I've ever witnessed or I've ever read about. So I agree that INEC should wield the big stick. So I got to know that more are still coming. More 24 political parties will still
be deregistration.
Yes, will still be registered. Because like my friend here said, most of them did not meet the requirements ab initio. The Nigerian factor came into it. They will go and borrow apartments and
no, but the lawyers here say that it was assumed that they met the conditions.
The mere fact that they were registered means
I said Nigerian factor. Few weeks after,
it's not. It's,
when things, sorry, sir, yes, sir. When things had cooled down, the apartments reverted back to their original owners. I can give you an example. The African Liberation Party also of Sheikh Okereke, at the end of the day, he is operating from a 2-room office in a shopping mall in Wuse 2, a shopping mall for that matter. He has an ante-room and the main office. He invited me to become the national vice chairman, Southwest. I accepted, and I was operating from my sitting room in Akure here. That is after INEC must have gone around, you know, that, like he said, they are supposed to be rendering, the parties rendering the returns periodically. And INEC will have woken up, will have gone to see those earlier offices, and so that they were moribund, nothing was happening. And like the electoral act said, or even the Constitution, you know, said that if for any reason, you know, INEC discovered that any party did not meet the requirements, okay, they would deregister such, or they would cancel the registration of such.
Okay.
In addition to what Baba said, you see, it's just unfortunate that we are in a country where the system is not working. Because when you look at Canada, we have everything is done online. This party registration, you just feed your document, and such findings and searches will be carried out naturally. And of course, they will find out if you are qualified to be registered or not. As I'm talking to you, we have 19 registered political parties in Canada, and 4 have been deregistered. So, but if INEC In Nigerian case, INEC did not bother to kind of find out properly. If INEC had carried out a thorough check on all this, they would have found out that most of these registered political persons were not even registrable at the point of registration.
Okay. Yeah, you were about to say
Yes,
something.
what I was about saying was, Chief, I agree with him to the extent that INEC can with the big stick. Because if you say INEC can register, but cannot register, and we cannot deregister, which means we want to encourage the culture of impunity.
Yeah.
I quite agree with him. But to say that having a multiple party is unhealthy, I don't agree with that. For instance, he has made mention of the Canadian experience. They have 19 parties. If you go to the United States, so many parties, though 2 are in the forefront. If you go to the UK, so many parties. In India, they have over 100 parties. So there's nothing wrong. But what we are saying is the viability of parties that we should have. That's where I disagree, or that's my point. That those parties must be viable for them to be. I still encourage INEC to do more deregistration so as to not to encourage a culture of impunity.
Okay then. Barrister Kayode,
Yes, sir.
in your opinion, how many of these 63 political parties are viable?
Well,